This is the current federal tax developments for the week of April the 28th, 2025. Current federal tax developments are brought to you by your state society of CPAs. This week, we're going to take a look at a few developments that have taken place over the past week. And we will begin this week by looking at a case that looks at the difference between a civil tax assessment and a criminal restitution order in a tax case, and how it's not the same tax, and the fact that one statute expires doesn't mean the other one does. So we'll talk a bit about that. We'll talk about a new innocent spouse case, looking at Salvi versus Commissioner, looking at what exactly happened here, and most importantly, why this spouse did not get innocent spouse release in her case. We're going to talk about the Supreme Court this week taking on and hearing oral arguments in the case of Commissioner versus Zuch, a case we discussed last year from the Third Circuit that looked at the tax court's jurisdiction in levy disputes if the IRS managed to collect the full tax while the taxpayer had filed in court to dispute a levy, by arguing that the assessment was wrong, the fundamentally underlying tax was incorrect because she didn't have a chance to challenge that position earlier. Can the IRS just moot the case by effectively having seized enough of her refunds in intervening years to have wiped out the tax? And there was a disagreement there between the tax court and the Third Circuit, and the Supreme Court is now stepping in to resolve that matter. And finally, we'll consider a Supreme Court case in a case involving the ERISA prohibited transaction claims and a lawsuit raised in that area, and what exactly a plaintiff has to be able to, what in essence they have to allege in order to bring such a claim. And we'll talk a little bit about how this Supreme Court decision probably makes it easier for complainants to raise the issue, although the court did point out there are some options that can make it less easy, or less of a problem if you have an abusive suit for the courts to deal with. But we'll talk a little bit about how that one worked. So let's start with our issue between a civil tax assessment and criminal restitution orders. This is the United States versus Charles S. Brown, case number C-24-5021. This is from the United States District Court for the Western District of Washington. And this decision came down on April the 22nd. Talk a little bit about what was going on here. Okay, here's the catch. Charles Brown filed fraudulent returns in 2004-2006, claiming improper withholdings. And we kind of know this because he pled guilty to criminal charges of false filing returns in 2014. So basically, he's done that. Now, at the time in January 2010, the IRS assessed civil income tax liabilities for the fraudulently claimed amounts. And they went, the standard assessment they would give, where they assess taxes because, hey, you owe me taxes. The standard civil one that hopefully is the only one we ever deal with. But in this case, when Mr. Brown pled guilty in 2014 to filing false returns, he agreed to pay, this is not a small amount of money, $1,252,181.54 in restitution. Now, interest was waived on the restitution. I know how much he reported over withholding. Well, it was not a minor amount, shall we say. Now, the IRS issued a restitution assessment in April of 2015 under Title 26, Section 6201A4, treating it as if such amount were a tax, which is what that section says. These were tracked in separate NFT 31 accounts on the IRS's internal systems. And in January 2024, the government sued to reduce the unpaid restitution assessments to judgment and foreclose on the related liens. Now, keep your time frame here. Remember, in 2010, they assessed on the civil side. So 2024 is going to be after the 10-year period would go away. So we're too late. The question is, can the IRS still come back and reduce to judgment the unpaid restitution assessment? When we're talking about that in 2024, or did they really have to do all of this by the 2020 date? And of course, Mr. Brown is arguing, not surprisingly, that the IRS blew it by not, taking this position and going to court and reducing the judgment, this unpaid amount, prior to the date in 2020 when the statute died. The IRS is saying, no, we had additional time. No, and we have more time under a different statute. Now, the taxpayer argued that the restitution assessments were invalid second assessments of the same tax as the earlier civil assessments. And he contended that the civil assessments collection statute of limitations should apply. That had expired. He said the IRS can only assess the same tax once. So essentially, they can't assess that same tax twice. Now, the government provided Forms 4340 and the criminal restitution order as evidence of a proper assessment of the criminal, restitution order and the notice. And the court's initial finding was they found the government's evidence sufficient to establish liability. So now that shifted the burden to Mr. Brown to prove that those assessments were incorrect. That essentially, they were assessing the same tax twice, and that was prohibited, so that second assessment doesn't count. Now, the court, after listening to Mr. Brown's theories, concluded that the restitution is not the same tax. And this goes to language that we see in many places in the code. You'll treat something as if it were X. For instance, a net 1031 gain is treated as if it were a capital gain. But the question sometimes come up is if something has to be a true capital gain for something to happen, does it count or does it not count? And this court said that in this case, Internal Revenue Code 6201A4A, that used the phrase as if such amount were a tax, that indicates it's simply a counterfactual hypothesis for assessment and collection, not a literal equivalence, meaning that we only say that because it's not a tax. So effectively, we're going to go through and treat it as if it was, but it's not really a tax, and therefore it's not going to be governed by the limitations on assessment of a tax per se. So Section 6201A4C also prohibits, challenges in a restitution arrangement further on based on the existence or amounts of the underlying tax liabilities when you get to a proceeding under the Internal Revenue Code. And that Mr. Brown's argument saying that, in fact, that was an invalid assessment, that's something he had to litigate at the criminal case level, right? He had to take care of that before he made his agreements to plead guilty and accept the plea agreement under the criminal case. He didn't do that there. He had to raise it. That was the venue to say that the IRS would be, prohibited, essentially, from doing this second assessment. Since he hadn't raised it there, and, appeals were long gone, tough luck. He's going to get it. So the court pointed to Internal Revenue Code section 6501C11, which allows the IRS to assess a restitution or to pay tax at any time, rejecting his second assessment theory. Because quite often, let's face it, a restitution order for failure to pay tax is really, in theory, only going to exist in most cases if there's also a civil, basically a civil liability out there that the IRS would be able to go against. So they're saying it doesn't make sense to have that in 6501C11 if, in fact, the IRS can only go after based on the civil statute. They're saying, no, this is a separate ruling and a penalty ruling that you have to follow independently. You can't get around it by saying, hey, we ran out the clock on the civil assessment. Now, there were some other arguments he made. He said, hey, but what about the fact they entered it as an MF31 module separate assessment? And the court said that's an internal IRS process. It's based on the Internal Revenue Manual. But it does not have the force of law. It does not create or remove rights from a taxpayer. Now, that's something you sometimes have to watch for here because it gets confusing. But in most cases, when we talk about the Internal Revenue Manual, it may be useful from a practical standpoint It's very useful normally in getting the IRS to do things if you can point out that the IRM says you must do X, must not do X, whatever it says. But if push comes to shove and we get to the courts, we're generally outside the realm of the practical, what you could get an agent to do, and into the realm more of the theoretical. What are they allowed to do? And, the court said in this case, and in general, the IRM does not have the force of law, and it did not give the taxpayers any additional rights that aren't conveyed by the code. The court said, look, the restitution liability is a legally separate liability from civil liability and is not a determination of the civil obligation. That's still technically something the IRS has to separately establish. And to be honest, they're probably going to be able to do it because, your plea of guilty in a case like this, if they hadn't already established a civil liability, would probably be considered a concession and get you there, but it is a separate liability. The court also found foreclosure of restitution liens was appropriate under Internal Revenue Code 6321 and 22, as the liens arose upon assessment, notice, and demand, which Mr. Brown conceded that would be true under those sections. And so the court granted summary judgment to the government, allowing the reductions of the restitution assessments to judgment, the restitution assessment to judgment, and foreclosure on the liens on the property. So, Mr. Brown, bad day at the courtroom. So what are some of our key takeaways from this case? Most important thing to remember, if you have the unfortunate situation of having a client who has both a civil and a criminal liability for taxes, they are restitution, they're ordered to make restitution or criminal provision for tax liabilities, and they are most likely civilly liable for the same, that those are not the same assessment, especially at the statute of limitations level. So essentially, you can't use your standard clock of running out the clock on the civil assessment, letting the 10 years expire, hope the IRS doesn't do anything, and then you're safe. That's not true in this context, at least per this court. The IRS can assess the restitution even after civil assessments for the same conduct. You can have two separate assessments. It's not a problem. The civil statute of limitations does not bar the restitution claim from going forward. So they could still assess a criminal restitution amount even if we are past the date that they could collect on the civil liability. Remember, you also cannot go to in a case under Title 26 Internal Revenue Code, you cannot challenge a civil restitution amount saying that wasn't the proper tax. No, you signed off on that, right? You're not allowed to litigate that issue. As the court pointed out to the taxpayer in this case, you had to litigate that back in your criminal case. You had to, in essence, you could have gone to trial in a criminal case. Of course, you might have gotten worse off, or you had to make that part of your plea agreement to back off there. But, you can't wait until now to raise this issue, right? Internal IRS procedures typically do not create taxpayer rights. As I said, the IRM is usually very useful from a practical standpoint, but don't necessarily believe, there are exceptions, but don't necessarily believe that it creates actual rights for the taxpayer out of the blue. It may help show that the IRS behaved, shall we say, in an objectively, wrong manner, or not wrong, shall we say, but certainly arbitrary and capricious manner. If they didn't follow the IRM, that you could try to argue that's evidence of that in some extent. But that's different from like this case where, they basically, nothing in the IRM said they couldn't do this. So those procedures, now they did it, did not create it. And remember too that the criminal restitution and civil liabilities have different purposes. The civil remedy aims at collecting the tax due. Your client that left $2,000 of dividends off the return because they didn't give you that 1099, they face civil penalties. And the reason they're only facing civil is had no criminal intent, but they still didn't pay. And this just looks at collection. You talk about criminal restitution, it's supposed to serve penalty-based goals and, hopefully increase rehabilitation on that background. So because of that, they have totally different purposes, and it wouldn't make sense to combine them under the one statute for only tax collection. And that's how the court arrived at it. Next, we're going to go on to an innocent spouse case. This is a case of Joanne Salvi Vanover, though the court will consistently refer to just Salvi because she's divorced. So in any event, versus Commissioner, so you'll see this referred to quite often as Salvi versus Commissioner, Tax Court Memorandum Decision 2025-37. This case also came down from the tax court on April the 22nd, 2025. Let's talk about this background of Joanne's case. Now, the tax years at issue were 2017 for an underpayment and 2018 both a deficiency and an underpayment on joint returns filed with her former spouse. Now, she sought relief under 6015, specifically subsections B, C, and F. We'll talk about each one of those briefly as we go forward. Now, financially, they had separate accounts and they had joint accounts. Ms. Salvi, Joanne, primarily paid the bills. And that's key here, right? There was a prior unpaid joint return in 2017 led to an IRS installment agreement. And Ms. Salvi suspected Mr. Vanover had prior tax issues in 2017 at the time she's signing this joint return. Now, 2017 had a balance due, and a 2018 return initially omitted Mr. Vanover's income, later revised but still unpaid. Now, the IRS issued a notice of deficiency for unreported income of both spouses and a retirement distribution of Mr. Vanover. So now we, of course, get to the place where Joanne's now divorced the guy, and she's looking to get out from having to pay the tax assessment, wanting him to pay it. Now, her claim was she was unaware of his prior tax debts and inaccuracies. She didn't really know. She might have suspected, but she wasn't aware of those prior issues, that she had difficulty obtaining information from him. She claimed there was spousal abuse and that he had financial control over her. Okay. Now, the IRS, she made a request to the IRS, which you do for innocent spouse relief, and the IRS denied her relief request. So she now took this up with the U.S. Tax Court. Now, the tax court established they had jurisdiction looking at Section 6015E, and they applied a de novo standard of review. They're going to review the whole case file, the whole case, what's going on. Now, remember, the taxpayer bears the burden of proving that she's entitled to innocent spouse relief. The default is that she signed a joint return. She's liable for every dollar that may be due there. I mean, if they can collect from her and not him, they could, they can take the money all from her, and it's up to her then to try to figure out how to get money from him for, let's say, whatever portion he should have paid. Now, the tax court also confirmed that your joint returns were filed for both years because, she stipulated, the IRS and she stipulated there was joint returns filed. That was a dispute, so that met the basic requirements to get into this whole area. Let's first go to 6015B, which provides for full relief for the understatement. Now, the court denied this. Under 6015B, you're not going to qualify for relief there if you have reason to know of the understatement that was attributable to the other spouse. And she had reason to know because of his known financial issues, historically had all kinds of problems, and his prior unpaid tax liability. That created a heightened duty to inquire. In essence, you cannot be intentionally ignorant of the problem. She had reason to know of the purported tax under 72T, which is the 10% additional early distribution tax, because the distribution was reported on the return. So very clear, she had reason to know about both those issues. There were things she should have inquired of. And that's the test under 6015B. And they said, well, for everything, she had a reason to know because she should have inquired, because it's clear her now ex-husband, she was aware at the time that he had financial issues, that there was definitely evidence of some prior tax issues, And, she really should have taken a closer look at the situation. But we went on to 6015C, and that's proportionate relief. And that's partially granted. As she was separated from Mr. Vanover, she was relieved of liability for the portion of 2018 deficiency attributable to his unreported non-employee compensation and that related 72T tax. Because there was no evidence that she actually knew about those items. She might have signed a return that showed the distribution triggered the 72T tax, but that doesn't mean she knew that it wasn't, didn't qualify for an exception to that tax for some reason. Actual knowledge is not to be inferred merely from the fact she has reason to know. So in essence, this is an easier hurdle to clear, but she's getting out of less this way, right? She had she in essence didn't have a reason to know, or she may have had reason to know, but she did not have actual knowledge. And we can't just infer that without something else. So finally now, okay, she got some relief, but still most of this thing is still on her. The court turns to the final option that she has, 6015F, equitable relief. Now, equitable relief allows relief when the taxpayer is not otherwise eligible for relief, innocent spouse relief, but given the overall view of the situation, it would be inequitable to hold that taxpayer liable for some or all of the liability. Now, the IRS has some interesting rules here that they use for this. And basically what they look at this, when they look at, this issue here for F, is, they're kind of looking for the threshold requirements, right? There are 7 threshold requirements. She met all of them except for the attribution requirements for the underpayment 2017 and a portion underpayment 2018, which they said were responsible for her insufficient withholding. But even if the court said the underpayments were attributable to Mr. Vanover, the problem is that equitable relief be denied based on other factors. So even though she met most of the threshold requirements, the streamline determination was not met, right? Because there are 3 conditions, including economic hardship, if not granted, and she could not show she'd suffer economic hardship. Based on her current income, about $85,000 per year, that exceeded 250% of the federal poverty guidelines. Therefore, the streamline relief was not available to her. Now we had to go the full analysis. And they concluded from the non-exclusive factors, which you're going to find in Revenue Procedure 2013-34, they evaluated them as this. First, the fact that she was divorced favored relief, right? She was there. That favored relief. Economic hardship, because that wasn't established, that was neutral. It was neither in favor or against offering, it's just not there. Now, lack of knowledge weighed against her relief, right? They found that she had reason to know the tax portion of the return would not be paid, given his prior financial issues, the unpaid 2015 liability. They did not find sufficient evidence of financial abuse or control by Mr. Vanover to negate this knowledge. And that's the problem. She said those were there, but then they've got to look at the record. Did she present evidence? You can't just say that. That's not going to be enough for the court, because that's what the court might consider to be, quote unquote, self-serving testimony. You're going to say that because you see you need to have that. But what other evidence was there? Is there corroborating evidence of some sort about, that he was abusive, or he exercised, kind of effectively an abusive level of financial control, right? The court cited a case, Thomason versus Commissioner, a 2011 88 tax court memo that talks about the fact you need some specificity regarding any allegations of abuse, not just general purpose. Legal obligations, it was neutral. Divorce decree's division of tax liabilities was subject to tax court modification per the divorce decree. So, that's irrelevant. No significant benefits. That did favor relief, as payments made were considered normal support. And in this case, they looked at a published tax court decision from 2011, Pullins versus Commissioner 136 DC 432. that regarded mortgage payments as normal support. Compliance. This was a problem because Joanne had varied tax compliance since she separated, including she was in court and she'd yet to file her 2022 return. So yeah, it didn't show that she was that great at her tax compliance. And mental or physical health, that was neutral as her claim of mental duress were raised late, and there was nothing in the record to back them up. So because of that, the court concluded it was not inequitable to hold her liable for the underpayments, and therefore the court denied relief under 6015F. So aside from the limited relief she got under 6015C, she was going to be on the hook potentially for this, and obviously if she's more collectible than he is, then she may be in trouble for those joint returns. Now, some of the key takeaways from this: understand the difference between reason to know under 6015B and actual knowledge under 6015C. Remember, your client's got to show that he or she had no reason to know about the understatement to qualify under B and get the broad relief. Under C, you can get out of portions of the tax on there to the extent that you show you didn't have actual knowledge of the issue, right? You need to have very good documentation of the taxpayer's knowledge of the spouse's finances and the items causing liability. In essence, as in most cases, records count. You got to gather concrete evidence to support claims of economic hardship, abuse, or financial control. The problem here was, she went in and she said all of those things should apply to her, but she didn't have much detail and she didn't have much cooperation that would suggest any of those would work for her, right? Also, if you're trying to get an instant spouse claim through, please make sure your client complies with the tax law in following years. That's not going to get him sympathy in court, especially for equitable relief, right? Complying with the laws is important. The point of this is not to let this person who's used to ignoring the tax laws, who appears to be ignoring the tax laws, to get away with something in those years. And also, recognize binding nature of any stipulations made before the tax court. Keep that in mind. There are stringent standards for relief, right? Innocent spouse relief has stringent requirements, and you got to have the facts back up to make it go. So that's it. We're going to close out this week then with 2 Supreme Court cases. Right? We haven't been there in a while. So first, we're going to talk about the oral arguments that took place on the 22nd of April in the U.S. Supreme Court in the case of Commissioner versus Zuch. This is a U.S. Supreme Court, oral arguments. This is case number 24416 before the court. And we're looking at this week at the oral arguments. There is both a transcript available on the Supreme Court's website. You can also just get the full audio itself if you want to actually listen to the issue. But we're gonna go from the transcript, since that's actually the one, the one that basically you can go read and download and you don't have to listen to. Let's talk about the background of this case. Right? Jennifer Zuch and her then husband filed separately but untimely for 2010. Okay, they both were late. They filed separate return. Jennifer's return showed an overpayment. Now, the problem was they had made estimated tax payments in both names, and they hadn't really properly gone with, when they filed the returns, to allocate how they're going to go. And as is not surprising, tends to happen at the IRS, I'm going to assume her husband was the lead name on the voucher. And those taxes tend to get, whoever's the lead name on the returns traditionally, would be where the taxes get posted. And that's what happened here. So they're credited to her ex-husband's account. And he had a substantial liability in play, right? A lot there. Now, the IRS issued Jennifer a final notice of intent to levy for the unpaid 2010 tax liability, hers, right? Because, of course, they took away the estimates. So even though she said she was overpaid, had they credited her with the proper estimates, The IRS says, no, 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 those went to the ID number that was lead on the vouchers. And rather, we've got this other number here. Okay. Now, Jennifer argued, she did ask for a collection due process hearings. She said, wait, those estimated tax credits, those estimated tax payments, they should have been allocated to me, right? That's what was going on. Now, the IRS Appeals Office sustained the levy, stating it couldn't move the credits. So at this point, Jennifer files in the tax court, right? She petitioned the tax court for review under Section 6330. Now, Section 6330 allows a taxpayer facing a levy, right, who has gone through the collection due process hearings and has had that, that levy, they're basically their request for relief denied, they can go to court to stop the levy. They can go to the tax court to challenge the levy. So she petitioned the tax court for review in this case, but she also, in this case, had not had a prior chance to challenge the tax liability. So before the tax court, she was saying that, in fact, the levy's wrong because I shouldn't owe the tax. The IRS improperly credited all of those estimated tax payments to my former spouse. And that was inappropriate. And her former spouse was even agreeing at this point that they should have been, that amount should have been credited to Jennifer's return. And so Jennifer's return should have been overpaid. Right? But while the tax court proceedings were in place, enough time had passed, and the IRS was seizing any refunds that Jennifer got on later filed returns and was offsetting the liability, as was going on. In 2019, when they grabbed that refund, they grabbed the refund apparently for 2018 returns she filed, her tax liability went away. There was no liability. And because of that, the IRS said, well, this case is about the levy, right? There's no longer a tax due. So there's no longer a levy that will be filed. Therefore, the 6330 case is moot. And that's true despite the fact that Jennifer was arguing primarily about the fact that there never should have been a liability for Jennifer, that in fact, that there was, the estimate should have been offset, and, that essentially she should get that money back is what she's going to argue. Now, the tax court ruled in favor of the IRS. They relied on the case of Green-Thappetti, which is a tax court published decision from 2006, 126 TC number 1. And they said because the underlying liability has been paid, the IRS is no longer pursuing the collection action. The 6330 case to challenge the IRS denial of relief from the collection action is moot. It's irrelevant. And it said in a 6330 proceeding, there is no authority granted to them to determine an overpayment or order a refund. So they have nothing they could do for Jennifer. Jennifer was not happy with that answer. Don't know why. I think might not be happy. And she appealed the decision to the Third Circuit Court of Appeals, which was the circuit with jurisdiction in this case. And in this case, Zuch versus Commissioner in 2024, the Third Circuit said the claim was not moot. Right? The court said 6330C2's distinction between issues related to the levy and challenges to the underlying liability are both listed there, right? It talks about issues, right, divides between the two in A and B. Because she had not received a notice of deficiency and thus not had a prior opportunity to dispute her tax liability, she properly raised the challenge to the liability in the CDP proceeding under 6330C2B. Right? So they're saying under 6330, she raised that challenge. Now, the Third Circuit disagreed with the tax court's reliance on its published tax court case, Green-Thappetti, finding the reasoning of that case faulty, meaning we think it's a fouled-up decision. The appellate court reasoned the tax court jurisdiction to review the appeals office determination regarding underlying tax liabilities, once invoked, can't be killed by the IRS universally finding enough money to grab from her to pay off liability without having to go through the levy. They can't get out of the question of whether they properly had an amount they should have been trying to collect from her. It also addressed the position on set-offs, right? It said and determined the setting off against disputed liability violated common law principles and Article 3 mootness principles that rendered them invalid, so that they, in essence, they shouldn't have offset. So in essence, and the court determined that if a tax court determined that she had a right to estimate payments, that wouldn't be an impermissible declarative judgment by the court, had been allowed to do, and that she was entitled to a credit for any amount of disputed estimated payments, and the IRS would have to repay that. That they had taken them basically without proper justification is how the Third Circuit looked at it. Well, now you may guess the IRS is the party not happy. So the IRS filed and asked for the Supreme Court to hear the case. The Supreme Court granted cert. And we don't have an answer yet what the Supreme Court's going to do, but what we did have this week were their oral arguments. Now, the government, right, basically, their counsel in the case, argued that the levy is the anchor under 6330, is the anchor of the tax court jurisdiction. Under 6330, this is a going to the tax court challenging the levy collection action. And that's the purpose of the case. If there is no levy being threatened, if the IRS gives up, says, okay, we're not going to impose levy, well, in this case, because they really couldn't because they've been paid, then the tax court lacks jurisdiction, even if underlying liability issues were raised, because this is an action to determine the validity of a levy, which no longer matters if there's nothing to levy. The IRS never levied on the property, and now they don't need to. They couldn't now levy, so it's a moot case. Now Justice Thomas directly questioned why the tax court wouldn't have jurisdiction if a levy were in place beginning of the litigation. And she, and basically the IRS, the attorney for the government said, look, this whole thing's tied to the levy. If once the levy's not there, once it's gone, this whole thing makes no sense. The relief the court could offer was to basically take away the levy. But with the levy not being there, the levy now being gone, it's like, that's not really going to do any good if we go forward. So it's a moot case. We also discussed what is a determination. Under 6330D1, a determination grants the IRS the jurisdiction to review the appellate office's determination. Okay. Now, while the government's attorney contended that the determination is specifically about whether the levy may proceed, and while subsidiary issues like underlying liabilities are considered making that determination, they do not provide an independent basis, per the government's view, for the levy to go forward, right? Once the levy's moot, we're done. Now, her counsel argued that the appeals office determination basically accommodates, or I should say, encompasses all issues raised, including the underlying liability. And the tax court had the right to review the entire determination. And so, Justice Gorsuch specifically asked the government's attorney, whether determination itself, which could include a contest of underlying tax liability, could provide the statutory hook. Now, obviously, she's going to say no, but it's one of those questions coming up. That's the sort of thing that the justice will ask, potentially to get an explanation on the floor, and maybe to try to address the concerns, or maybe even if the justice believes that in fact, without a levy, this thing's dead. He might want to get it, stated out there in the open, why the government believes that and deal with that issue. So that it's tough. That's why it's tough to read these, right? The IRS also argued that, there were other remedies, right? In essence, the taxpayer could pursue other remedies, like she could file suit in district court. Remember, as the IRS took those refunds, she could have filed a claim for refund, and she could have litigated in district court. Now, yes and no. she's got this thing sitting in the tax court, so there's a real question of what right she really had to go to district court. But then the other problem is, obviously, you're already litigating here. Even if they'll let you in the district court to challenge the offset, you're going in two places. And as her counsel pointed out, if you don't do that, the statute may die. Remember, once the IRS takes it, you got basically 2 years to file the claim for refund, and then you have, essentially, if the IRS denies your claim, you got 2 years then to file in court. So basically, the statute could die on you easily during this time frame, and that they said it's just not really fair. Those other options aren't really valid. Now, several of the justices were concerned about the implication of allowing the IRS to effectively moot a tax court proceeding by unilaterally finding some other place to take money from the taxpayer. Right? Justice Kavanaugh questioned how often the situation arises. And of course, Jennifer's counsel argued that Congress intended 6330 to provide taxpayers with a forum to dispute collection actions and unpaid liability for deprivation. Allowing the IRS to circumvent this process would undermine the purpose, right? That would be kind of the key issues there as to why it's there. Now, the government emphasized the tax court's a court of limited statutory jurisdiction and lacks general remedial authority, right, to remedy things, right? Particularly the authority to order refunds. And nothing in a 6330 says they can order a refund, right? This is different from 6512B in deficiency proceedings, which specifically grants overpayment authority. There is no such authority found in 6330. And finally, Justice Gorsuch raised the question of whether Article 3 mootness principles apply to the tax court, an executive branch tribunal. While basically nobody really answered that question on either side, this may be a nuance in the court's analysis where the case remains a live case or controversy. Right? Now, all we know right now is we don't have an answer for this one, right? We don't know what's happening. Now, what this means to us, we have to look and wait for this decision to come down, right? But some things it could mean. If the Supreme Court were to side with the government, right, and the tax court review and CDP proceedings could be narrowed when the liability is satisfied during litigation. You have to watch for that. Will the IRS be able to satisfy the liability via other mechanisms like seizing refunds? And you're going to have to kind of watch for that and be careful, right? Because if you're going to go to tax court and have to dispute it there, you got to make sure the IRS doesn't get it paid off somehow in the interim, right? You might need to pursue refunds in district court, even if the underlying liability was a primary issue in tax court. You're going to litigate this issue twice. Is effectively going to be your problem, because you have to kind of protect yourself in district court in case the IRS moots the case in tax court. That'd be the key. Obviously, it's really helpful to, before a levy takes place, go ahead and try to resolve the underlying liability disputes during the hearing process. Again, can't say for sure if there were other things that could have been done here. May very well have been the answer is no. But obviously, it's really, really important. So, let's go to tax court introduces a risk that you might have to seriously consider, even if you're not doing great. You think, or appeals, you don't think it's going to be useful there, you might still have to try it. And you really should. Everybody should keep an eye on this decision, especially if you do collections work, right? Because it could basically impact the handling collection disputes and the role of the tax court, and just complicate matters quite a bit. Okay, well, we don't have a decision from Supreme Court in that case, but let's go to a case we did. This is a case of Cunningham et al. Versus Cornell University. The Supreme Court case number 23-1007. The Supreme Court issued its decision on April the 17th. And this is an ERISA case. Now, we deal with qualified retirement plans, which is what we're dealing with here. There is joint IRS and Department of Labor jurisdiction, and there are a lot of provisions that are virtually identical you find in ERISA, and you've related with qualified retirement plans, and that you find in the Internal Revenue Code. And the whole prohibited transaction area, which is what we're going to talk about here, is one of those dual applications where it shows up both places. Right? So this case revolves around what exactly do the plaintiffs have to allege and provide sufficient, their allegations themselves be sufficient on their own to essentially get them into court or prove it. To basically means if the other party, the plan sponsor, doesn't present any information, right? They don't rebut anything. Have you presented a case that would give you basically, present a case that would, where you would carry the day. And this goes into the questions of prohibited transactions. And we get here, going to go into something. I remember an attorney that retired a number of years ago. I remember once having him say that, discussing these kinds of issues and saying, you have to remember the law says prohibited transaction, not prohibited only if it's bad for the plan. And that's kind of where the Supreme Court comes down here. We'll talk about that, right? This was a class action lawsuit by employees of Cornell University regarding their defined contribution retirement plans during the years from 2010 to 2016. Now, the employees allege that Cornell University caused the plan to engage in prohibited transactions under ERISA 11061C by paying excessive fees for record-keeping services to TII and Fidelity. Or TIAA, I should say, and Fidelity. Now, we're quite used to that. Quite often you will have, a company offer to provide the record-keeping services and other things, and they provide the investments, all that stuff. And they'll do it all as one. The question becomes, is that a prohibited transaction? And more importantly, how we determine if it is. Now, the employees of Cornell University allege that TIAA and Fidelity were parties in interest, and that their fees, $110, $115, $200 per participant, significantly exceeded what they said was a reasonable fee of $35. Now, we're going to find out that eventually the appellate court is going to decide that they didn't really provide proof of why that would have been excessive for this kind of structure. And that's going to be the key issue ultimately that we get to the trial court, or we get to Supreme Court, is going to be the question about whether it could be dismissed based on the fact that they, had not included in their allegation, any reason why these fees, a reason that by itself would be sufficient as to why these fees were excessive. Now, ERISA section 1106A1C and an equivalent 4975 in the Internal Revenue Code prohibits a plan fiduciary from causing a plan to engage in a transaction that the fiduciary knows or should know constitutes a direct or indirect furnishing of goods, facilities, or services between the plan and a party in interest. And, a party in interest is anybody providing services to the plan. There's a broader definition of that, but in this case, going to be there. Now, what the Supreme Court says is that particular section, 1106A1C, is categorical, right? A prohibited transaction needs to be the fiduciary caused the plan to engage in transaction. The fiduciary knew or should have known transaction constituted direct or indirect furnishing goods or services or facilities. The transaction was between the plan and a party in interest. If all three of those are done, that is a prohibited transaction. Now, however, there is a defense found in section 1108. Right? That provides a series of exemptions, right, that would allow you to, even though under 1106 this is a prohibited transaction, you skip out under an exemption. There's also ways you can get the Department of Labor to grant you an exemption. There are various ways of getting in here. Okay, so that's going to be where we look at. Now, when this went to the district court here, the district court kind of went against what my attorney friend years ago said and said, well, you've got to show some evidence of self-dealing or disloyal conduct, or it's not a prohibited transaction. Now, I believe And by the way, I believe the Court of Appeals is probably correct that that's not the appropriate standard, right? It's prohibited. But the Court of Appeals said that because of the exemption in 1108 B2A, and there are a whole series of exemptions, there's a bunch of them, the plaintiffs needed to plead the transaction was unnecessary or involved unreasonable compensation. Because if it was a necessary transaction and the compensation was reasonable for the value received, then that exempts you from the 1106 category. And the Second Circuit said that, they merely said, they quoted these numbers, and they didn't consider why that might have been. They didn't provide evidence of why that was, not necessarily that there were lower, that, it's not enough to merely show there is a lower fee available somewhere, because that it's not illegal to charge. Everybody doesn't have to go to the lowest common denominator. But you do have to, the catch is you've got to show that what they're paying extra beyond what they would have gotten, let's say, for that other fee, did not get them services in line with the amount being charged. And the Second Circuit says, well, you didn't allege that, so we're going to throw the case out. Obviously, the employees disagreed with that view. And the Supreme Court agreed with the employees. They reversed the Second Circuit's ruling. They said the exemptions in 1108 do not impose a pleading requirement for 1106A1 claims. It basically, the burden of proof is on Cornell to show they meet the exemption. It is not on the employees to prove they don't. So it's a burden of proof problem here. And because it's an affirmative defense have to be proven by the party who's advancing them. They said, so you cannot require the party filing the suit to refute every possible 1108 exemption. Like I said, this isn't the only one. They're saying, nope, can't do it. Now, we know that their argument is that they expect that, they believe the justification Cornell is going to use is the one that says it was a necessary fee. It was a necessary fee and the necessary service, and the compensation was reasonable. And probably necessary is probably there because record keeping will be required. The question really would become, is the fee reasonable for the services they get under this program? Or should they have gone out with the super cheapy version at $35? What in essence, how did the fiduciary determine the value? Which, by the way, is something important that you should be aware of. You definitely need to, especially as in this case where the plan is paying for this out of plan funds. Now, if we talk about closely held companies who have put plans together for tax planning purposes, you may very well find the company paying these directly and not having the plan carry them, which basically should moot this in those cases. But if you have a plan that was really established just because we had to have a 401k in order to be competitive, in this market for employees, then the company may very well say, well, we're going to go ahead and we're just going to kind of, we don't want to be paying for anything more. So we're going to go ahead. The plan can pay it. We're going to have the plan pay it. And obviously that is what Cornell did, right? We're going to have the plan pay the money. Makes sense. There's very little advantage to Cornell to having the university pay the fees, except for the fact that, they probably wouldn't have had this lawsuit if they were, but that's a different issue, right? Now, a plaintiff alleging a prohibited transaction only needs to plausibly allege the three elements of Section 1106A1C. That the fiduciary caused the plan to engage in a transaction. Cornell University contracted with TIAA CREF and, Fidelity to provide all of these services, right? They knew or should have known it was a furnishing of goods, services, or facilities. Obviously, it's record keeping. That's services, right? We know it, right? And the transaction was between the plan and the party of interest. And effectively, everybody gets paid by the plan is going to be a party in interest. So essentially, you can argue virtually anything that the plan pays for can be a tax or prohibited transaction. I agree, that's kind of what it is here. They are the plaintiffs that are filing suit under this provision from the transaction provision are not required to anticipate and negate the applicability of every single 1108 exemption. Because again, it's not just one. There are other exemptions there, and they're not required. The Second Circuit had effectively put this one in there as kind of a special requirement. Now, you might argue that they're saying, look, real world, this is what the fight's over. They even kind of admit it's what the fight's over. But, the Supreme Court said, nope, you can't add that there, right? This is it. All of the 1108 exemptions, including the one for necessary service, no more than reasonable compensation, 1108B2A, are affirmative defenses, and the fiduciaries bear the burden of pleading and proving an exemption applies. In essence, it is a prohibited transaction, period. However, if you qualify for an exemption, then the problem goes away. But that's something that the plan has to show. And that's probably important to remember when you're working with your own clients. Remember, when they decide to choose, especially if the plan's paying the fees, when they decide to choose something, right, to choose a particular vendor, for whatever reason, they do have to consider essentially the welfare of the participants is supposed to be the driving benefit. They're a fiduciary. They have fiduciary duty. So if you are paying more than, what somebody could say, hey, you could have gotten this done for X, you need a justification as to why it makes more sense to pay TIAA and Fidelity a higher number than, super, super cheap plans, Inc., a much lower fee. You've got to be able to justify what they provide, which quite often you can. There's lots of reasons why it's better to pay the higher fee. But you have to have shown you considered it. You didn't just ignore it saying it's not a problem. We don't care because the employees are going to pay it out of the plan. So why would we care? So we're just ignoring it. No, that's a violation of your fiduciary duty. You got to make sure you've considered this issue. Now, implication for you if you're advising a company with a retirement plan, because quite often, unfortunately, you may be as the outside accountant. In many cases, especially when the clients are kind of quoting doing a do-it-your-own plan, you may be the main party advising them, and everybody else has disclaimed responsibility. Right? You'll find that quite often. So you are unfortunately the person sitting in a bad position as the quote plan expert, at least in the client's view, because you're the only pro that's there that hasn't really disclaimed responsibility if you begin to advise in this area. You have to be careful. It reinforces the importance of understanding the prohibited transaction rules. Clients have to understand these rules are there. And I do agree with the attorney I mentioned to start this. Prohibited means prohibited. Prohibited does not mean prohibited, but it was good for the plan. It was a good investment. It was whatever. It's prohibited, and if it is, and every contract with the service provider effectively is prohibited transaction, then you've got to assure that you've justified that you fit the exemption, right? We need to have that justified. And clients have to understand it's their burden to show that. It's not the burden of the employees complaining, to show that it doesn't qualify for the exemption, right? While direct impact is on litigation, that's what the court's ruling it. You got to really be aware of the fiduciary responsibilities that come with establishing a retirement plan for employees. And the more this plan is primarily for the benefit of the employees, where it's really been done because we're trying to hire people because they know there's a checklist that employees look at when you're going to hire somebody, potential employee, of do they have a 401k plan? And so you want them to check that box, yes. You got to make sure you understand that you have to consider, you got to make every decision about service providers with a view toward, the benefit to the employees. That includes if they're paying for it inside the plan, you have to do a cost-benefit analysis. And you can be nailed either way, right? Because if you get an incompetent party in there that was cheap, and things go wrong that way because all the accounting screwed up, people got the wrong numbers, the wrong people were in the plan, everything was screwed up and some people didn't get in the plan at all who should have. That can also violate your fiduciary duty. So you got to be aware of that, right? So you need to be able to say, can we show that we meet the exemption? And the most important thing is to document and rationally consider why we chose this service provider. And preferably it's not just because, my brother-in-law works for them. That's probably not a good reason, right? So this decision clarifies the pleading hurdle for plaintiffs to do. But again, fiduciary duty to ensure compliance exists, period. You need to be able to show this, and it's easier for the employees to take you to court, in this case. So that's an issue. And by the way, that was one of the complaints, that even there's a concurring decision that suggests a real problem here is the way this law is written. It's going to encourage a lot of frivolous suits. Well, the majority opinion did cite several tools available to district court to address meritless claims. In essence, you could have, under Federal Rules of Procedure 7A, you could order a reply to an answer asserting an exemption. So there's an answer that comes back and says we're qualified for the exemption under this. You could require an answer, which now is going to require the other party to put forward legitimate objections as to why you don't qualify. You could dismiss for lack of a concrete injury under Article 3. What does that mean is, again, if they can't show that they're, in essence, they're saying ultimately their damages are going to be the fees, right? The excess fees. Well, if they have any evidence of excess fees, if they can't, show excess fees, when we get the injury phase, it doesn't matter. It's a prohibited transaction. Bad on you, plan. But it does you no good if somebody does bad, but there's no damages, then there's no case. Generally, there's got to be a remedy. The court can say, look, I have no remedy, right? Fine, good. It's a prohibited transaction. But, so how do I make you whole? You got to show me, because obviously record keeping has to take place. So how do I make you whole? And in order to show those damages, you would have to have at least some evidence in that regard. They can put limitations on discovery to stop fishing expeditions. If it's clear, there can be sanctions imposed, and there can be cost shifting for the frivolous suit under ERISA Section 1132 G1. So they said those are the options, but the plan's got to realize that still fundamentally it's easier to get the case into court, right? We don't necessarily have to prove. At the very least, as I said, since we're talking about if you're going to use the reply to an answer asserting the exemption, the party asserting the exemption will at least have to itself present what would otherwise be a prima facie case, right? A case that would stand on its own without some rebuttal. So you have to at least be able to come in and in your pleading, give the argument about why you're going to qualify for the exemption. That you're going to show A, B, C, and D. And having shown that, that would show your qualification for the exemption. And now it'll be up to the other party to say, no, we're going to show, X, Y, Z. And that would force them to essentially do that. But again, it does force the plan to first come up with this theory about why they're, in essence, that they qualify for the exemption. That'll be key. So the conclusion, this case does clarify pleading standards for any prohibited transaction claims that go to court. The plaintiffs only need to show those three elements to get in the door. They do not have to show that the fees were, that what was paid for was unnecessary, or that what was paid for, was an exorbitant fee. They might need to be able to come up with a reason why they're going to assert that in order to show damages or to be able to counteract what the plan is going to argue, but that's a different issue. The 1108 exemptions are all affirmative defenses. The plans must show them. So again, you got to talk with clients with a plan. Yes, we're going to have service providers, we're going to be paying them. So you got to consider, this rule about whether you can show that it was necessary. That's normally relatively easy. But then number two, although again, if you go too many bells and whistles, you have an issue whether it's necessary. Then number two, is the fee in line? And that really normally requires a fiduciary at least have checked elsewhere to see what others are charging for this. it's kind of hard to say, oh yeah, it's like going to a car dealer, right? And just buying the car off the lot without ever looking to see, what's actually going on. What are people really paying for this car, or what are comparable cars being sold for by other dealers, right? That's not the best way to get to get the right price for your car purchase. That's kind of how it goes. Same thing here. So again, fiduciary responsibility is important. And again, your problem is that if you're the tax person, you may not like it, but you may be considered the expert the client believes they're relying upon for these things. You're not an attorney. Fine. I know you're not an attorney, right? I'm not an attorney. But the problem is they're going to claim you should have told them about these things. Or you should have advised them to go get legal counsel. And no, I don't want to pay for an attorney until after the lawsuit gets filed. And then suddenly like, why didn't you have me go get an attorney early? It would have solved all this. I can't believe you didn't do that. I can't believe you basically, you didn't fulfill your requirements because you failed to tell me I need an attorney. Yeah, they'll do that. This has been the Current Federal Tax Developments for the week of April the 28th. Again, as always, I am available at Zollers at currentfederaltaxdevelopments.com. You go there if I can. I'll try to get around to answering if you put something there. I also do watch the posts on the Connect sites for Arizona, New Jersey, Minnesota, Illinois, and Washington, as well as Idaho, right? Idaho added it later, so I always forget that toward the end. But Idaho added it later, so I do look there for those things. Otherwise, we look forward to seeing you next week as we enter the month of May, which technically, the way CPE works for most state societies, that means we enter a new CPE year come Monday, or not Monday, actually, it's next Thursday. We'll enter, or this Thursday we'll enter a CPE year, but we'll be there. So CPE goes again. We'll talk a little bit about that maybe too next week as to how we get CPE going, because there are a few changes coming on my end that we'll be looking at for that purpose. But otherwise, have a good week, and we will see you in the future for current federal tax developments.